Kim, the floor is yours.
Thank you. Hello, everyone. My name is Kim Heinrich, and I handle marketing for Meritas. I would like to welcome everyone to today's Meritas Capability Webinar, U.S.-Canada Cross-Border Litigation, 5 Things American Lawyers Should Know About Litigating in Canada. Our webinar is scheduled for 60 minutes today, and our presenter is Meritas member Stephen Maddex of BrazeauSeller.LLP in Ottawa, Ontario, Canada. Stephen is one of very few lawyers in Canada with considerable litigation experience in the United States. Now, prior to his joining BrazeauSeller, Stephen practiced for many years at 2 large law firms in Houston, Texas, where he gained significant trial experience. During this time, Stephen appeared in courts all over Texas, including the Texas Court of Appeals. He is also licensed to appear before and has appeared before the United States District Court for the Southern District of Texas and the United States Court of Appeals for the Fifth Circuit. At BrazeauSeller, he is an associate and senior commercial litigator. Now, before we get started, I wanted to walk through a few housekeeping items. As everyone has probably noticed, your phone lines are muted. However, we do encourage you to interact with our presenter, and you can do so by using the chat feature, and that's located on the right-hand side of your screen. So you can enter in a question there and hit submit, and that will go directly to the presenter, and he'll be answering all questions at the end of the presentation. Should you experience any technical issues, you can hit *0 at any time, and someone will come on the line to assist you. So with that, I will turn the call over to Stephen. Are you ready to get started?
I am.
Excellent. Thank you.
Okay. Well, I also want to thank everybody for participating in the call, taking time out of your day to hear me talk about my thoughts on cross-border litigation. And I guess the place where I'll start really, I guess, is right there in the title. You know, a lot of people who do some kind of aspect of cross-border litigation have their own kind of definition of it. I mean, the things in their own practice that they relate to cross-border disputes. And so the term itself, cross-border litigation, I think is a little bit difficult to nail down. I'm not going to talk about things like enforcement of judgments or cross-border discovery, enforcement of letters rogatory, those kinds of things, even though I think those are some of the things that a lot of people associate with cross-border litigation. I'm going to talk about the things that I've sort of found to be maybe the most surprising, the most shocking things about Canadian litigation or litigating in Canada when I came back from Texas to Ontario, which was about 4.5 years ago. About 4 years ago, I started practicing here. And there were a number of things that, even though I was born in Canada, I didn't know anything about Canadian law. And I, had my entire legal experience, all my legal training in the U.S. So I really knew nothing at all about litigating here. And so just over time, I've kind of, stumbled on some things, and I thought, geez, that's crazy. How could that possibly be the law? It makes no sense. So these are the kinds of things that I've found to be of interest, and I think they would be the kinds of things that U.S. lawyers would find surprising if they had a client who had a case in Canada or had had some sort of reason to be engaged in the litigation process in Canada. And I think also for any Canadian lawyers on the line who might listen to this recording, things that they might want to know that U.S. lawyers might want to know. And I guess what it boils down to for me when I think about cross-border litigation is Canadian bacon, and I'll tell you why. When I was in law school, I had a good friend of mine who, maybe the second week of class, walked up to me and said, is all bacon in Canada Canadian bacon? And I thought to myself, I didn't even know what the term Canadian bacon meant. I'd really never heard it before. So in my mind, I thought to myself, he's talking about bacon that's made in Canada. And of course, I found out later on that what he meant was what we call in Canada back bacon. And it sounds like kind of a silly question, but he was really curious about it. He wanted to know, is all bacon in Canada Canadian bacon? And I kind of looked at him and I thought, well, and I said to him, if it's made in Canada, then I guess it's Canadian bacon. And I guess he interpreted that to mean that yeah, all bacon in Canada is Canadian bacon. So he asked me again, is there no American bacon in Canada? And I didn't know what he meant. I thought by American bacon he means bacon made in America. So I said, well, I guess if it's made in America, it'd be American bacon. If it's made in Canada, it's Canadian bacon. And so we went around in circles for probably about 5 minutes, and then fortunately class started. But I didn't realize that what he meant by Canadian bacon was, back bacon, and he didn't realize what I meant by Canadian bacon was bacon made in Canada. And we're both speaking the same language. We're both using the same words, but we're not communicating. We were literally lost in translation. And it's a very simple example of how, because the Canadian legal system and the U.S. legal system have a lot in common, we use a lot of the same words, we have a lot of the same sort of procedures. But the way they work out in Canada, it oftentimes is completely and totally different from the way it would work out in the States. So if you're a lawyer in the U.S. talking to a lawyer in Canada, and vice versa, and you're talking about discovery, you're talking about costs, or you're talking about jurisdiction, or those kinds of things, you may not realize that you're talking about two completely and totally different concepts. And if you don't realize that, then you are literally lost in translation. So those are the kinds of things I want to talk about today, and that's hopefully I can help alleviate some of those problems down the road, that you'll understand that when you're talking to a lawyer on the side of the border, that you might need to be a little more careful in defining your terms, and maybe you'll have a better idea of what's going on and how you can hopefully implement better strategies and more cost-effective ways to get the result your clients want. So with that, we'll move on here past the housekeeping slide. Now, I apologize in advance for the junior high school looking geography lesson here, but this is, I think, an important place to start, really, because when I think about cross-border litigation, I think about just how pervasive it is, because Canada is, here's a map of Canada, obviously, and Canada is all of this here. If you can follow the pointer here, this is all of Canada, and this obviously is the United States. And I think I don't know if this is necessarily still true today, but typically, generally, about 90% of the Canadian population lives within 100 miles of the U.S. border, and that's important because there's really so much trade that goes across the Canada-U.S. border, and I think that quite often just how pervasive the trade relationship is lost sometimes in the media. But Canada and the U.S. are still Canada is still the United States' single largest and most important trading partner in the world. And if you take cross-border bilateral trade between Canada and the U.S., Canada's number one by far. And number two, I think, is China. Number three is Mexico. If you combine China and Mexico together, the bilateral trade between the U.S. and China and the U.S. and Mexico together combined is only slightly larger than the cross-border trade, bilateral trade between Canada and the U.S. And that's every year it's the same. And so the trading relationship is so huge. And when people trade across the border, people move across the border. And when people move across the border, and there's business relationships that are created and transactions that occur so pervasively, there's bound to be disputes. And those disputes, of course, sometimes land on this side of the border and sometimes land on that side of the border. So I thought I'd start with just a kind of a brief look here. If you know anything about the map here, this is Ontario, the province of Ontario, and this is Ottawa, where I am. And Toronto here is the largest city in the country. This is Quebec. I'm not going to talk at all, everything, and I'm going to mention this here in the next slide, but everything that I have to say today, by and large, you shouldn't expect it relate to Quebec. Quebec is a civil code country, province. They follow, and Quebec follows the civil code. So the rest of Canada, all the other provinces and territories up here in the north, and the provinces here, are common law jurisdictions, and we'll talk about that in a moment. But some of the things to keep in mind now, Ontario and Quebec are the two largest provinces by population. British Columbia is also, I think, probably is third, and Vancouver here on the west coast. If you have clients who are engaged in oil and gas, there's a good chance that they may have a dispute that's in Alberta, Calgary here, and Edmonton here. And so these are kind of, I'd say, Ontario, Quebec, Alberta, and British Columbia here, probably the ones you're most likely to encounter, the jurisdictions you're most likely to encounter. Okay, so as I just kind of mentioned, the legal framework, what you're likely to encounter in Canada, and again, I'm talking about everything that I'm going to talk about today does not include Quebec. We're talking about generally the common law, and that should give you a little bit of comfort, because if you're dealing with a common law jurisdiction, then the substantive law, by and large, is going to be the same. And one of the things is there may not be as much case law here, simply because there's much less litigation here. And so, the law tends to change, I'd say, maybe a little bit slower than sometimes it would change in some places in the States, simply because there's just fewer decisions, fewer common law, fewer judicial decisions that would change the law. So a lot of what you're going to look at for contract or tort, property cases, by and large, is going to be common law based, and there probably won't be a lot of significant differences unless your jurisdiction has removed itself from the common law in a substantive way. And I'll give you an example of that. In Texas, for instance, I think probably quite some time ago, they eliminated all of the common law defenses that relate to negligence claims. So if you're talking about last clear chance, those kinds of things, they're all sort of subsumed within comparative negligence. So that's a diversion from the common law. But Canadian jurisdictions, by and large, probably still would apply those common law exceptions. Now we have a federal constitution, and the charter here I've indicated here. That's the Charter of Rights and Freedoms, and it's kind of like the Bill of Rights, but it's a little bit different. I think the only real point to be made here is that although we do have a constitution, we don't have provincial constitutions, so there's no state constitutions. And so if you're thinking about some sort of constitutional rights that might apply in your jurisdiction, odds are they wouldn't apply here. So those would be some things to look for. And the general kind of constitutional framework is relatively analogous, but we don't really have, like, for instance, due process. We don't really have the same kind of due process rights that you would find in the U.S. We have similar kind of concepts, but it's not really the same. So I think the point there is simply if you think to yourself, well, this conceptually would make sense in the U.S. because of some sort of constitutional framework, I wouldn't expect that it necessarily be the same here, although we may have a similar kind of legal concept that we wouldn't necessarily view as a constitutional right. Now, this next slide, personal jurisdiction. I'll tell you, this is maybe the most difficult to explain, and the reason for that is simply because we don't really have the same kind of concept of personal jurisdiction in Canada that exists in the U.S. So, and what I mean by that is we don't even call it personal jurisdiction, and there's a bunch of different sort of terms for that, but by and large, the difference is, traditionally, that courts in Canada would take jurisdiction over a claim, not a person or a defendant. So when we think about personal jurisdiction in the U.S., you think about the traditional minimum contacts analysis and the right of a court to assert jurisdiction over a defendant. Well, in Canada, we don't really have that same concept because the courts here traditionally view their role as taking jurisdiction over a claim, and that can create some really big distinctions. So, and not only that, but I think just the way that the concept of jurisdiction is viewed in the U.S. is fundamentally different from the way it's viewed here, simply because people don't think about it that hard. So quite often, if you're trying to decide, if you're a plaintiff, where are you going to sue? Where can you sue this defendant? You tick through your mind all of the kind of minimum context thing you think about. Can I get jurisdiction over this defendant? Well, in Canada, we don't really have that same kind of concept. And I can tell you that when I first started practicing here, I'd ask people about it. And it was really hard to get my head around it because nobody here really understood what I was talking about. In other words, I was asking questions they didn't really even understand, where I was going with it. So if you're having a conversation with a lawyer on the other side of the border and you're talking about the concept of where you can bring suit, you have to understand that in Canada we really just don't look at it that way. And so there's really no kind of knee-jerk reaction to the idea of suing somebody in a place where they've not created minimum contacts. Like, many many lawyers in the states would think, well, that just doesn't make sense to me. How could you be sued in a jurisdiction where you haven't established minimum contacts? And whereas here it doesn't mean anything to them, or at least doesn't mean anything in the same way, in my view. So you can forget about minimum contacts analysis, by and large, and think about and what a Canadian lawyer is going to tell you is that the court has jurisdiction over the claim, and if it meets a certain kind of test, and that's what we'll come to here in the next point, Van Breda. So what happened recently, I think this decision came out in April. The Canadian Supreme Court issued a decision. It's called Van Breda, and there's been a series of cases kind of going back a little bit in time where courts in Canada have been struggling with this concept of personal jurisdiction and how to define it and determine when a court has proper jurisdiction over a claim. And the traditional rule was, let's say going back, say, 30, 40 years, that courts really were very plaintiff-friendly. So as long as the plaintiff had a sufficient connection and the plaintiff's cause of action and the plaintiff's damages had a connection to the jurisdiction, then the court would say it has sufficient jurisdiction over the claim. The claim is defined as who the parties are, including the plaintiff, who the witnesses might be, what law might apply, where the damages occurred, where the events occurred, and maybe, let's say, what kind of law would apply. And courts were sort of balancing all these things out. And quite often, what it would boil down to was whether or not there was a sufficient contact with the claim overall, weighing all those things together, balancing them out, with really kind of I would say, in reading the cases, in my view, really kind of heavily weighted in favor of the plaintiff, that the plaintiff really had the right to pick jurisdiction. And if you objected to jurisdiction, well, the courts would kind of say, well, what difference does it really make? I mean, is it really that big of a deal to make a defendant, a foreign defendant, a U.S. defendant, defend in Canada? Is it really that big of a deal? And if you're weighing that against, the burden on the plaintiff to have to go down to California or Florida or somewhere in the States and bring a claim where they economically couldn't do that, then I think there was sort of if not a written kind of response, at least a kind of a practical kind of response, that it wouldn't make sense to make the plaintiff go do something that would be so unreasonable when they can just bring the claim here. It's all the same to them. So I think if there had been a general trend in the law the last number of years, it had been kind of, in my view, more and more plaintiff friendly. And that could lead to really surprising results, because you could be a defendant, a U.S. defendant who's being sued by a Canadian, and you've never even been to Canada, never established any kind of connection to Canada. But the plaintiff did. The plaintiff went down to the States, got injured, came back here, and they're here. Their witnesses are here. The law between Ontario and Michigan wouldn't necessarily be any different, on a tort claim. So why not make the defendant defend? And it might be even more in favor of making the defendant defend if there are other local defendants. So a court would say, well, why should we make a plaintiff sue a local defendant here in one case and then make them go down to the States and sue basically on the same transaction and occurrence in another case against the U.S. defendant? It's just as a practical matter, just make them all defend one claim. So you can read decisions going back the last 10, 15 years where those kinds of analysis carried the day. And so you'd have U.S. defendants and other foreign defendants being forced to defend claims here without having any real rational connection of their own being established in that jurisdiction. And then, as I said, in April, the Supreme Court of Canada came down with this decision in Van Breda. And interestingly enough, the case was argued to the court a year earlier. So they took over a year to reach this decision, and it really, in a way, kind of changes things. And what Van Breda said was, well, we need to have kind of a general overall approach that applies in all jurisdictions across Canada to kind of settle it and decide, let's try to create some more kind of a much more structured framework, I think is really their intent. Now, how it's going to work out, we don't know. So this is maybe just kind of a guideline. And what Van Breda has said is, the court said, is that when a court is deciding whether or not there is, as they say, a real and substantial connection between the court and the claim, that courts should take into account, and they've listed 4 factors. And one is whether the defendant is domiciled or resident in the province, whether the defendant carries on business in the province, whether the tort was committed in the province, or whether a contract was created in the province. So those are just kind of general kind of guidelines. That's not minimum contacts analysis, but it's a step closer to that. So how this is going to play out over time, I don't know. But I think the message to you is that if you have a client who gets sued in Canada, and you ask yourself why were they sued in Canada, there may not be a really particularly good definite answer to whether or not a court's going to hold on to the claim or not. And that's simply because the law is kind of in flux. And Van Breda, I think, is designed or was intended to create some structure. I don't know how courts are really going to interpret it. And I don't know if the traditional kind of knee-jerk reaction that plaintiffs get to pick their jurisdiction, if that's not at least subliminally going to carry the day. It can make resisting jurisdiction in Canada an uphill battle. Now, I don't know that it always will in all cases, but this is a very, very important key distinction between litigating in the U.S. and litigating in Canada. It's one that can have a real, real big impact on what you do next. Costs, attorney's fees. Now, this I think, the difference in how attorney's fees are awarded. I'm going to talk about it in detail here in a moment, but this is probably, in my view, the single most important, single biggest difference between litigating in Canada and litigating in the U.S. And this, to me, having done both litigating there and here, I can tell you this one crosses my mind every single day. And costs, as it's called here. So this is the term is costs, right? And when we're talking about costs in Canada, we're talking about attorney's fees. We're not talking about court costs. We're not talking about court reporter fees or any of that. It's nominal. We're talking about attorney's fees. So if you get an email or a letter from your local counsel in Canada who says, look, we're going to get costs awarded against us, what he means or she means is attorney's fees. We're not talking about court costs. We're talking about, potentially tens of thousands of dollars, right, like real money. The general rule is, in common law Canada, because I think the rule in Quebec is different, but generally speaking, broad strokes, in common law Canada, the prevailing party is entitled to recover their costs, their attorney's fees, in all cases. Now, how that rule is applied from jurisdiction to jurisdiction might be different. In other words, the amount that's awarded might be based on a different kind of calculation. But by and large, that's the rule. And that's true at the end of the day, when the case is tried. At the end of the day, the prevailing party, now whether you're the defendant or whether you're the plaintiff, is entitled to their costs. So if you win, you get your costs. Now, the other part of it is that it can also be recoverable on motions. So if you bring a motion and you lose, you have to pay costs. Now, how much you have to pay, it could be based on a scale, or it might be a defined scale. I think in Alberta they use kind of a scale. I don't know that for certain. In Ontario, it's up to the judge's discretion how much they'll award. And typically they'll award either, say, 60%, or they can award 80% of your actual costs. So the way it would play out is, let's say the defendant brings a motion for summary judgment and loses. Then after the judge rules, says, motion denied, then the plaintiff's lawyer would stand up and say, Your Honor, I want my costs. And then the lawyers then would have an argument about how much the plaintiff should get in costs. And sometimes, every judge can do it differently. They might award an actual percentage of the actual amount incurred, or they might just kind of pick a number. It depends on what that judge might think is fair. So, but it can be a real number. And if you're talking about, for instance, a motion to dismiss a case, we would call it to stay on jurisdiction. So let's suppose you get sued and you want to bring a motion to dismiss the claim against you because you don't think the court should have jurisdiction over that defendant. You bring that motion. It can be very expensive to work that one out, and you might wind up, if you lose it, you might wind up paying the other side, $30,000, $40,000 in costs. It can be very significant. It all depends on how it's calculated, but that's what you need to understand, is that You bring a motion, you lose, you pay costs, and it can be a lot. And I think for that reason alone, I think lawyers, by and large in Canada, common law Canada, are much more reluctant to run down to the courthouse. So you see an awful lot less, I think by and large, less motion practice across the board. I mean, in Texas in our practice, we'd go down to the courthouse, regularly. There would be no, if you really thought you had a legitimate motion, or if you had some other kind of reason to go down in front of the judge, you bring your motion, or you go down there and you do whatever you need to do. You wouldn't think to yourself, well, I'm going to have to cough up $20,000 in costs if I lose. Whereas here you have to really think it through. So I think by and large, that has a real impact on how people manage their cases. It also has an impact, I think, on the kinds of claims that people are willing to plead. So fraud, for instance, is generally regarded, by and large, broad strokes now, as more like a crime than it is kind of a claim. Now, I mean, obviously in the States, you wouldn't hesitate to include fraud in a claim. Whereas here, because it's a very serious allegation, and if you lose on a fraud claim, a judge might really hammer you on costs. So if you allege fraud and you don't prove it, then you might, and even if you can prove another claim, it's possible that you might have to pay costs for failing to prove fraud, and it could be a lot of money. So the kinds of causes of actions you really want to plead, you got to think through, and how you make the allegations, how you word your pleading, you got to think through, because if you have kind of a sloppy pleading, and the defendant then right out the gate brings a motion to strike a claim, or for some kind of clarification or some sort of procedural motion on your pleading, and they win, you have to pay costs. So you want to really sort of think through, exactly how you take each step, and I think you have to be a little more careful. And if you've got a client that's not inclined to want to pay $20,000 in costs to their sworn enemy right out the gate, that could have a real big impact on what happens next. And I think a lot of lawyers really, they take that into account in their strategy. They think, if I'm a defendant, if I can get the plaintiff's lawyer in front of a judge on a motion that I think I can win, and I can force the plaintiff to choke up $20,000 in costs right away, that could end the whole case. So, if you think about it psychologically, the kind of impact that could have on your client, on a plaintiff, it could be significant. And those aren't the kind of things that we would think about in the States normally. And so the other thing of it is that it's a percentage of costs. It's a procedural kind of mechanism. It's not a substantive right. In other words, it's not a substantive part of the claim. Whereas if you have some sort of a statutory claim in the States that permits the prevailing party to recover their attorney's fees, that's a substantive right. Whereas here it's procedural. So it's really kind of more discretionary, and it's more designed as a mechanism for judges to control the processes of the court. So it's not really, you won't find necessarily, I'm not aware of any, statutes that specifically provide that the prevailing party can recover their attorney's fees, because it's all sort of thought through. That may be different in Quebec, for instance, and there may be some statutes where that's considered, but it's really it's a procedural mechanism that applies sort of across the board, and it's an important part of the practice. The third thing here is security for cost. The rule in Ontario, I don't know exactly how these rules are worded in other provinces, or if other provinces have them. I suspect they probably all do. But security for costs is basically a bond that has to be posted with the court, or it could be put in trust with the lawyers. But it applies to plaintiffs, foreign plaintiffs, who bring an action in Ontario or in Canada. So if you're a U.S. plaintiff and you sue in Ontario, you can be required to post security for costs. And the idea being that if you're a foreign plaintiff and you bring a claim and you lose, then the defendant should have some means to recover any costs award, attorney's fee award against that party. So, and it can apply in other circumstances as well. That can be a real big hammer. So if you bring a lawsuit here and the other side says, well, I want security for costs, they want you to post a certain amount. It's kind of a bond. that would make funds available to the defendant in the event the plaintiff loses. So look out for that one, security for costs, and it could be structured sort of sequentially, where either the parties will agree or the judge would impose kind of a certain amount through discovery, and then another amount through through trial. But it could be significant, and it would be theoretically it's based on a reasonable estimate of what the defendant's costs will be. So if you think about what you think an overall what the bill would be, what the attorney's fees would be on a case, the actual fees incurred by the client, it could be hundreds of thousands of dollars depending on the case. So a plaintiff under the right circumstances could be required to post a very significant bond or security for costs, depending on the circumstances. So that can be really really kind of a game changer. Okay, now discovery. Now I said that attorney's fees costs is the biggest. I would say that probably this is the second biggest. The limited rights to discovery, as I've described it here in the slide, and this applies really in a couple of different ways. First of all, there's scope. The scope of what is discoverable is significantly less here, by and large, and then also the mechanisms of what you have available for discovery are significantly less, or tend to be significantly less. Now, scope. Now, the rules in Ontario, at least, and I don't know if I imagine it's probably across the board in the country. The rules used to be what was discoverable would be documents or information that relates to the case or relates to the facts pleaded. And then recently, the last few years, in Ontario at least, the scope of what is discoverable has been limited to documents that are relevant to the case. And I would say, to me, in my view, having practiced in the States and having come here, to me, there's really not that much of a distinction between the two. And what you were entitled to under the old rules, or what you're traditionally entitled to anyway, wasn't really a whole lot compared to what you'd be entitled to in the States. So it's documents and information that are really relevant to the dispute. And that's, in my view, that's really narrow. It's really kind of more like, the way I look at it is, the documents that you're entitled to, by and large, are documents that are really relevant to the actual facts pleaded. And if you want a specific document or a specific question answered in an examination, deposition, and if you can't show how that information really relates to the case, how it could really be more like evidence at trial, if you look at it that way, then they don't have to hand it over. And so it's a very narrow scope, and people take that seriously. So it's not like you can get away with asking the other side to hand over all tax returns, let's say, or any kind of document that that you might find interesting, or maybe could lead to other evidence, or maybe you think is tangentially related to the case. If it's in that kind of range, you're not going to get it. Odds are you're not going to get it. So the scope of what is discoverable is much more closer to really relevant. Now, as far as what you're entitled to, as far as mechanisms of discovery, you really kind of get two things. You're going to get some documents. We'll talk about that in a minute, and you get basically one deposition. And here we call them discoveries, examinations for discovery. So the lawyers here will call them discoveries, and as opposed to depositions. But you really only get one, and it's kind of like an apex deposition, or like it can be an apex deposition. It's kind of like a one designated, if you're talking about a corporation, one designated representative who will represent the corporation at that examination for discovery, and they're there to answer all your questions theoretically. Now, their role, ideally, they should take on the responsibility of gathering all the relevant evidence, right? So if there are people within the company who know specific facts, theoretically they're supposed to go ask them that before they're discovered, before the deposition. As a practical matter, it probably wouldn't work out that way. But you get one, and in Ontario, you're limited to 6 hours, 7 hours. So you get really a very limited right to actually ask questions under oath of the opposing party. And again, the questions you're allowed to ask are only those that are relevant. And I get called on this all the time when I take depositions here. Lawyers are always like, that's not relevant. And I have to stop and think to myself, what's really the relevance of that question? And if I can't answer it, well, then I don't get to ask I don't get to ask the question. And they'll instruct the witness not to answer, and I'm stuck. So that's really kind of all you get. You don't get to examine experts before trial. You have very limited non-party discovery. So any witnesses who are not parties, any witnesses to the case, you can't just depose them. You can't just send them a subpoena. Not entitled to do that. You need a court order. And to get a court order to discover a non-party, to examine a non-party, it's pretty high burden. So the likelihood of actually doing that, pretty low. In 4 years, I haven't heard of anybody getting away with it or even trying it. So pretty much, by and large, you're going to get some documents that are relevant, and you're going to get one deposition. We don't have interrogatories. You do have a right, I suppose, under the rules to ask interrogatories, but it would be in lieu of your deposition, so you get one or the other. So there's no interrogatories, and there's no request for production. The way that you get documents is that each party has the responsibility to examine their own records and decide for themselves, based on their examination, what documents they have that are relevant to the facts pleaded, and they have to produce those. And that's really kind of all you get. Now, you might be able to during your deposition, you might find out that there's other more relevant documents or documents that nobody had thought of. So you might say, well, if in your pleading here you say that Tom spoke to Jim. Do you have any documents relate to that? Oh yeah, there's some emails. Okay, we'll hand over the emails. But that's kind of typically how you might get to more documents. You could theoretically bring a motion to compel the production of more documents, and I'll come to motions in a minute. But that can be difficult too. So as a practical matter, I would say by and large you're going to get what you're going to get. Now, that wouldn't necessarily be true in a class action or some kind of other larger scale litigation. But the process of getting documents from the other side can be very difficult, and we'll come to motion practice in a minute. But it's very you're kind of boxed in. And then the last sort of thing here is proportionality. Now, the last few years there's been a proportionality, this concept of proportionality in litigation, which basically is this: that costs incurred. It applies across the board, not just with discovery. But the idea is that parties should take into account the amount in controversy and the costs associated with completing a certain task and kind of weigh it out and decide whether or not that's proportional to the matters at issue. It's kind of broad strokes basically what it is. And if you think about if you're objecting, let's say, to a request for production, in the states on the basis that be unduly burdensome. It's basically that, unduly burdensome. Now, it's a relatively new concept, and I don't know that people are really, as a practical matter, walking down to the courthouse and saying to a judge, based on proportionality, we shouldn't have to do this. I don't know that you're really seeing judges make those decisions. And so how that's going to impact things, I don't know, but it's in the rules. At least it is in Ontario, and I think it probably is in British Columbia and other places as well. And so the idea is that if you're at an examination for discovery at a deposition and you say to the other side, you haven't produced any emails between that person, and I think they're relevant and I want to see them. They could say, well, but it's going to cost us, $50,000 or whatever it is, $10,000 or something, to examine our records and produce those emails. And they could theoretically resist a motion, if you brought one, to compel the production of those emails on the basis that it would just cost too much. And how that's going to play out, I don't know. But it's kind of the X factor nowadays in discovery, and really sort of as I said, it applies across the board. I don't really know how it's going to play out, but it's really, if you think of it this way, it's really kind of a resistance to discovery, I think, in my view. And the fact that it's getting some grip across the country is kind of like, I think that many Canadians view what they've seen anyway with respect to runaway discovery in the States, and they say, well, we don't want that to happen here, so we're going to apply proportionality. And I would say in response to that, well, it couldn't happen here, because the scope of discovery is already limited to relevant. I only get what's relevant. And so you can't prevent me from getting something that's relevant because it would cost too much, because then I'm not getting relevant evidence. So, I don't know how that's going to balance out, how it's going to play out, but that argument is kind of in play. Now, I mentioned briefly that you don't have any right to request for production, and that's because I think, as I said a minute ago, that you don't have the right to compel anybody or ask anybody to produce documents. Each party has its own individual responsibility to voluntarily produce their relevant documents. So that's all you get. You get the documents that they voluntarily produce. Now, you can ask for more, but ultimately that's kind of where it goes. You don't really have a right to send them a request for production that says, within 20 days or 30 days, or what the rules are, produce these, 50 categories of documents. That doesn't exist. You have no right to do that, and nobody does it that I know of, and they wouldn't have any responsibility to respond to it. So, you can ask. I've done that. You can say, I've got the documents you've produced, and I don't see anything that says this. I don't see anything that says that. Where are they? And so you can ask. You can have that discussion, but it's not the same thing, obviously, as a request for production. Okay, now I noticed that we had a question a moment ago. Here's the question. Does recovery of costs apply in litigation against the government? Yes. As far as I know, if you're in litigation against the government, and if they lose, they can pay costs. So there's no real, that I'm aware of, any real distinction there. At least I would say as a general kind of principle, I don't think you would find. Now, there may be some exceptions that may be in specific jurisdictions, specific rules, and specific circumstances. Maybe you couldn't, but I think that'd be very limited. I think just as a general kind of rule across the board, nobody's immune from that. It's an important, and again, it's a procedural device, so it's within the judge's discretion, by and large, to decide who pays what and when. Motion practice. So setting apart for a moment, just that generally speaking, I think there's much less motion practice here than there is in the States. This is how motion practice is done. I'm just only going to cover this very briefly. I don't want to get into it too deeply, but how we go about it is very different. And I think the key things are that for every motion, by and large, now there can be some exceptions, but by and large, you have to have evidence in support of a motion. So, like a good example of that would be if in your jurisdiction you have a no evidence motion for summary judgment rule. There's one in Texas, where you just bring a motion that says the plaintiff has no evidence of a cause of action or an element of the claim, and your motion might be a couple of paragraphs. You don't have any evidence in support of that because you're saying there isn't any, right? So we could have certain motions like that where there's no evidence to consider. If it's a motion to strike a claim, the court's only going to look at the pleadings. By and large, across the board, if you want to bring a motion, you've got to have evidence in support of it. A good example of that would be a motion to compel. So if you're bringing a motion to compel production of documents, you've got to have evidence that shows that they have documents that are relevant, they haven't produced them. And if you don't have that evidence, then you can't prevail on the motion. By and large, broad strokes, right? So what most lawyer, I guess the normal procedure is you file what's called a motion record. And the motion record would be a notice of motion, which is kind of like if in federal practice you do your motion and then you do your brief and support separately. It'd be kind of like that. The notice of motion is kind of like a notice document that simply says, this is we're moving on these grounds, this is the relief we want, and here's the basic sort of facts that support that claim for relief for that motion. And then attached to that, part of the motion record, you'd have your affidavit, because like I said, you got to have evidence. And the affidavit would say, here's the facts and here's the evidence that supports it. Now, one of the key things, and I'm going to come to this here in a moment, we talk about court administration, is that you're always, generally, by and large, you're probably going to be in front of a judge who doesn't know anything about the case, because cases here are assigned to courts, not judges, by and large. So whatever you want the judge to read, you've got to have as part of your motion record. So if you want the judge to know that that the pleadings say X, Y, Z, you've got to attach the pleadings. They won't have the file with them. So you've got to be sort of comprehensive in that sense. So you have to have your motion record, notice motion, and your affidavit. Now, one of the biggest distinctions here in motion practice is that anybody who submits an affidavit in support of a motion can be cross-examined on that affidavit. So that's another mechanism of discovery available to you potentially. So you submit an affidavit, and then the other side gets an opportunity, depending on how the motion plays out. But the person who gives that affidavit can be cross-examined on that affidavit, so you can get some discovery there. And then the transcript from that cross-examination, from that deposition, can then be added to the record for the motion, and then you'll have that thrown in also. Now, I've noted here the lawyer as a fiant. So one of the rules here is that if you have a lawyer who gives an affidavit, they can't argue the motion. By and large, generally that's kind of the rule, is that a lawyer can't be both the affiant and the person presenting the motion. So whereas you might in your general practice you might submit declarations on your own behalf or whatever and say, look, I had this conversation with opposing counsel and he blew me off, and so here's my motion for sanctions. You wouldn't be allowed to sign the affidavit and stand in front of the judge and argue the motion. So that's another kind of key point. So okay, so that's motion practice by and large. Now, the last slide here is court administration. And what I just said a minute ago is that cases here are you file it with a courthouse, and there's a registrar who maintains those files, a registrar of the court. So cases aren't assigned to specific judges, and that can be that can have a real big impact. So by and large, you're always going to be in front of a different judge, and once your case is assigned to trial, the trial judge, you won't know who the trial judge is until it's actually assigned to the trial judge, and that could be whatever, a week or a couple of weeks before trial. So you won't know who your trial judge is until you get there. And I've been in, for instance, San Antonio and Austin, also in Texas. They have a similar kind of a deal where they call it like a rotating docket. So every time you go down, even though a case is technically assigned to a court, to a judge, that judge doesn't manage the case. So every time you go down to a hearing on a motion or whatever it is on a file on a matter in San Antonio or Austin, Texas, you're going to be in front of a different judge. So you show up that day, and you're assigned randomly to a judge who's available. Here it's kind of the same thing, except you could be in front of a different judge every single time. And again, they're not going to have the file, so they're only going to have what you put in front of them. So that can be a little bit difficult because you don't really know who's going to be making the decision, and you can't really gain steam, right? You can't really get a sense of how the judge is reading the case over time, those kinds of things. And it can be much slower because you've got to get in front of a judge, and the registrar has to assign you to a judge to hear a motion. So things tend to move slower, and there's no real control over the docket, right? So you don't have a judge who's pushing his files, who's pushing his docket, saying, look, you guys have been on this thing for 2 years now. You're not going anywhere. Try it, settle it, decide. Judges here, they don't do that because it's not their responsibility, that file, right? So it can take much more time to get to trial. It can take years. There's no real control over the file in the sense that we don't get scheduling orders from the court. The lawyers, by and large, to work out the dates on their own. So there's fewer controls over the file. It takes a great deal more time, quite often, to get things moving. And here's kind of the kicker. There's really relatively few in civil cases, jury trials. So most cases are tried to judges. And as I said a minute ago, I won't go into the details of that, but as I said a minute ago, you don't know who your trial judge is going to be until you get there. So it can be really difficult to predict the result. And if you're in a jurisdiction like Ottawa or Toronto or big cities where you have a bunch of judges, and there could be a huge broad array of personalities, and you never really know what you're going to get till you get there. So it can be really difficult to predict. and obviously you can't make decisions based on your anticipation how you think the judge is going to lean because you don't know who the judge is. And the last thing I have here is that there can be a high emphasis on settlement. I know that's generally true across the board, but there's in Ontario, before you can get a trial date, you have to go to a pretrial conference, and the pretrial conference is a settlement conference where you're in front of a judge, and the judge will look at the case, look at the pleadings, and kind of talk to the parties and say, y'all need to settle this, and that's after mediation. So you have required to mediate, and then you're required to go to a pretrial where the pretrial judge might try to get you guys to settle, and then 6 months later you're going to go to trial. So you should sort of expect those kinds of steps. It can be really difficult to get to trial in Canada. So that's basically it. We did have one question a minute ago, and if you have any more questions, feel free to fire away now on the chat tab here.
Stephen, this is Kim from headquarters again. Thank you so much for that great presentation. I'll just take up a couple of minutes here in the event we get some more questions in, but appreciate everyone for participating today. Wanted to let everyone know that within the next couple of days you will receive from headquarters a link to a recording of this session as well as a copy of the presentation materials, so that will come shortly.
Kim, we do have another question here I'd be happy to answer. We got some time.
Excellent.
The question here is, how do the Canadian courts deal with contracts that contain choice of law and choice of venue provisions? That's a real good question. The answer is it depends. So choice of venue provisions, I think, and choice of law provisions, I think, generally would be enforceable. But I think also courts will take into account whether or not there is a real connection between the choices in the contract and the contract itself. So, for instance, if you have a contract between a Canadian company and a U.S. company, and they've chosen, the law of, Germany or France or something like that, that has no real connection to the dispute, then Canadian courts are probably not going to enforce that. Choice of venue provisions might be the same. But the thing you should keep in mind about choice of law is that in Canada, the rule here is, by and large, that foreign law has to be proven by quote-unquote expert testimony. So if you have a case here that's governed by U.S. law, ultimately you're going to need an expert, i.e. a lawyer from that jurisdiction, to come up and testify about the law. And if you have as an expert, and they'll be subject to cross-examination and all that, you have competing experts on the law. And I know that a lot of U.S. jurisdictions do the same thing, but I've seen judges in the States who would just simply say, look, we're talking about the law, so I'm not going to put anybody to the stand under oath. Just get up and argue the case law. Canadian judges won't do that. They view it as it's kind of a cross between fact and law, right? So which can be confusing on appeal. But if you have a motion, let's say a motion for summary judgment, and the law and the case is governed by the law of California or whatever, then in support of that motion, you're going to need an affidavit from a lawyer who's going to say the law of California is X. And as I said a moment ago, once you sign an affidavit and submit it in support of a motion, that affiant is subject to cross-examination. So it's not like it would be there where a lawyer probably wouldn't ever be cross-examined on an affidavit or a declaration about the law. Here they are subject to cross-examination, probably would be cross-examined on the law. So if you sign an affidavit in support of a motion in Canada, beware. Be careful. Okay, any other questions?
All right, well, that looks like that might be everything. And everyone, we will send around Stephen's contact details in that follow-up email that I mentioned, so you have a chance to reach out to him should you have any additional questions that come up. So, Stephen, unless you have anything else to add, we can close the webinar.
That's it. Thanks, everybody, once again, for participating. I really appreciate it.
Thanks again. Take care. Bye-bye.
Okay.
Yeah, it's true.